Hi, this presentation is a presentation about the GDPR, the General Data Protection Policy, with a particular emphasis on those elements of the General Data Protection Policy and data protection legislation that radio stations need to consider. First of all, let's have a look at the general legal matrix of in which data protection law arises. It is an aspect of Irish privacy law. We have under the Irish Constitution a constitutional right to privacy. There are also international treaties that protect our privacy, most notably the European Convention on Human Rights, which became part of Irish domestic law in 2003. In addition, we have data protection legislation, which is coming more and more to the forefront as a result of recent developments culminating in the GDPR. Interestingly, there's also one explicit piece of legislation that addresses privacy, and that's under our broadcasting law. Section 39(1)(e) of the Broadcasting Act 2009 restates a principle that has been in place for many, many years, since the 1960s, which is that in the making of its programs and in the broadcast of those programs, a broadcaster, obviously including a radio broadcaster, must not unreasonably encroach on the privacy of an individual. So that is the general legal matrix in which our privacy law arises. And obviously today we're going to focus particularly on data protection legislation. The evolution of data protection law, it's interesting to look at this from the point of view of how it emerged. The principles of data protection law emerged actually in post-World War II Germany, where there was such horror at how personal information about individuals had been manipulated and used by the Nazi regime that there was a sense that there needed to be legal protections to prevent this arising again. This took on an international dimension and led to the adoption of the OECD guidelines on the protection of privacy and trans-border flows of personal data in 1980 and the Strasbourg Convention in 1981. These principles were incorporated into Irish law by our Data Protection Act in 1988, which at the same time, at an EU level, there was an attempt to harmonise data protection law right across the EU, which led to the EU Data Protection Directive in 1995. We had an amendment to our Data Protection Act in 2003, and then a further EU directive, the e-Privacy Directive, in 2002, which led to the e-Privacy regulations in 2011. Now, all of these affect data protection law. I want to take a moment to talk about the distinction between EU directives and EU regulations. An EU directive is a piece of EU law which is passed at EU level, and then a certain amount of time is given to member states to incorporate that law into their own domestic legislation. There's another form of EU law that is called a regulation, capital R. And a regulation, capital R, is an EU law that has direct application. It comes into effect immediately on a specified date right across the EU. And this is the type of law that the most recent General Data Protection Law is. It's a General Data Protection Regulation. It comes into effect right across the EU on the 25th of May of this year. It doesn't replace existing data protection law across the EU. It enhances it and gives individual data subjects enhanced protection for their personal information and enhanced control over how that information is used. What is personal information for the purposes of data protection law? Sometimes it's referred to as personal data. The actual terminology of the regulation is personal information, but we'll use those terms interchangeably: personal data, personal information. It's information, first of all, about a living person. It doesn't apply to people who are deceased. So it's information about a living person, and that living person can be identified from that information or identified from that information and any other information that's likely to come into the possession of the data controller, the person who's collecting the data and deciding what's done with it. So any information that identifies or potentially identifies an individual should be treated as personal data in accordance with data protection legislation. There's another level of protection applies to what's known as sensitive personal information. Now, sensitive personal information is, yes, identifying information, but it's identifying information about a living individual that gives information about the individual's racial or ethnic origin, religious beliefs, political opinions, health, sexuality, their criminal record, their genetic information, their biomedical information. And as we'll see, there are slightly different levels of consent. Where you are handling sensitive personal information, consent can't be implied to doing anything with that information. You must have the explicit consent of the individual to collect and process, and we'll see that means doing anything with the personal information. There are occasions, for example, phone-in competitions to a radio station, where consent can be implied, and we'll look at that. But that's for general personal information. If it's sensitive personal information coming to into this category of information that has even more enhanced protection, you must have explicit consent to process, to handle that information. The GDPR defines consent as any freely given, specific, informed, and unambiguous indication of the data subject's wishes by a clear statement or a clear affirmative action signifying agreement to the processing of the personal data relating to her or him. I think a very useful way of looking at this, because it's a way that radio stations collect personal data and process it, use it, is when you run on-air competitions and somebody will send in personal information about themselves, their name, their email address, their name, their mobile number, in order to win the prize. It's very important to state on air the purpose for which this information is required, why you're asking them to provide the information, and the clear affirmative action by the data subject indicating, signifying their agreement to the processing of the personal data they're being asked to supply, is the fact that they enter the competition. This is why it's so important to be really clear when making a call out about a competition, or making any kind of a call out asking listeners to send in their personal information, that you are very, very clear with them about why it's required, what it's going to be used for, and it's used only for those purposes. We'll see a bit more about this and what you may and may not do with that information later on. And we'll also answer the question, which I know you're going to want answered, which is about passing on information to Media Central, Urban Media, and or the sponsors of prizes. We'll come back to that. It's very important, if you're running an online competition on your website, for example, that you don't have any pre-ticked boxes. Nothing is assumed. If somebody is giving their information and there are terms and conditions applying, they must opt in. It can't be deemed that they've accepted terms and conditions. The consent clause can't be buried deep in lengthy terms and conditions. Make sure the consent issue is well highlighted. And if you collect information, for example, for the purposes of running a competition, and then want to create a marketing list for your sales and marketing department, you need to go back to the individuals and say, can we use your information for marketing purposes? You can't, if the information has been supplied solely for a competition, you can't reapply it to other uses unless you go back and get extra consent. Now, if you'd asked at the start and said on air, in applying for this competition, you need to know that we'll also be using your information for marketing purpose. And it's highly unlikely. It's a real mouthful. But it may be, and this is what I was mentioning a few moments ago, that let's say Boots or Lidl are running a competition and they want to get your information. Or I'll tell you one that I came across recently, where a bank was asking a radio station to run a competition. But they wanted to be able to, the bank wanted to be able to contact the people who went to the competition. So it's very, very important that when people are entering the competition, they know that their information, that it's made clear to them that their information will be shared with the sponsor. So if the information is going to be shared with anybody else apart from you, you need to advise the listeners of that. A record of the consent / affirmative action should be kept. Now, usually you're going to have records of your station output. Certainly you keep it for at least 3 months. I believe that period has been lengthened by the BAI. And so you have some evidence that the presenter made clear what the information was being sought for. In some situations, data subjects must be informed in advance of giving consent of their right to withdraw consent at any time. It must be easy for them to do so. It's usually applicable where the organisation is collecting the data, is making money directly from the processing, such as marketing companies. That doesn't need to worry you too much. Now, this is really important. It crosses over privacy law and specifically data protection law. Consent from children. If you are running an on-air if you're running a website competition, for example, or anything that requires children to provide you with personal information about themselves, what their name is, where they live, perhaps even where they go to school, you should be sure that you have parental consent. Now, a lot of radio stations have been quite horrified to hear this because they have morning programs where kids call in and talk about what's happening on the school run, or what kind of a day they're going to have, or at Christmas time they're calling in. You do need to have a system whereby you at least make some efforts to check that where the children are likely to be under 13, that you get you run some kind of checks to try to establish that they do have parental consent. So, for example, that the mum or dad needs to call in and the producer needs to talk to the mum or dad and say, your child is going on air, will be giving personal information about themselves. Are you all right with this? Mum or dad says yes, then put the child on. Now, you need to be very careful. It's not a fail-safe method, but at least means that you've made some effort to ensure that children under 13 who are giving information about themselves, have personal information about themselves, that consent has been sought. How will you verify or confirm parental consent? Consider possible mechanisms. As I said, it may not be foolproof, but at least you've made some effort to try and get parental consent if you run it through the producer first, rather than putting the child straight on air. If you're running online competitions, if you're running a website competition, there should be a box ticks that I'm over the age of 13 and give a parental email, get the child to give a parent's email as well. If it's actually online, the children, if they have a Facebook account, should already have the Facebook account holders have confirmed that they're over 13 when they're signing up to Facebook. Unsolicited marketing communications. Those of you who are involved in sales and marketing are going to have personal information and personal data about individuals that you are communicating with in the course of your sales and marketing activities. This is information that you will have collected in the course of your business, or these individuals will have otherwise specifically consented to giving you this information. A lot of the time this information is publicly available, but you need to treat it as data to which the data protection legislation applies. You are entitled to hold data for the legitimate purposes of your company, company's business, but you must hold it securely. When it involves unsolicited marketing communications, you may email individuals with whom you've done business in the previous 12 months, but you must give them an opt-out provision if they don't want to continue to receive marketing information from you. So, for example, if you want to send out information to all your advertisers about your JNLR figures and say, look how well we did, look, your money is being well spent, this is the audience reach you're getting, that's fine, but you must give them, if they've done business with you in the last 12 months, but you must give them an opt-out entitlement. Otherwise, I would strongly, for all other communications, if you are doing what it effectively is cold calling, either by text, by email, by fax, by phone call, I do refer you to the direct marketing regulations, which are very usefully summarized on the relevant section. I give you a link to it there of the Data Protection Commissioner's website. They can be complex in that they apply slightly different rules to different forms of communication. I think what's most important for you to know is that if you are communicating with people with whom you've done business in the last 12 months, either looking for more business or reporting to them on the business you've done in an unsolicited manner, you must give them an opt-out provision. Processing personal information. I've used two terms, which is being the data controller and being the data processor. First of all, what we need to understand is that processing information is doing anything with it, holding it, storing it, filing it, accessing it, disclosing it, manipulating it, organizing it, adapting it, combining, blocking, erasing, destroying. All of that is processing personal data. Doing anything with personal data is processing. If you hold any data, whether on bits of paper or on files electronically, you are processing it. Controlling and processing. A data controller is the person who collects the data and is in a position to determine what's to be done with it, how it's going to be processed. The data processor is the person or the business that actually does the processing in the manner determined by the data controller. It may be exactly the same person. In most cases, stations, unless they outsource their human resources function or their payroll function, they will be both the data controllers and the processors. It gets a little bit more nuanced if you are collecting information for somebody else, or for example, if Puka or Oxygen or one of those SMS handling organizations are collecting information about individuals, their names, their phone numbers for you on your behalf, you're determining what can be done with that. And you need to look very, very carefully at the contracts that you have with those SMS text handling services to ensure that they are in collecting the data for you, and you are in a position to determine it, to determine what happens to it. In my view, that means you're the data controller, that you have very, very clear contracts with them about how they keep it safe, how and when they erase it, and that they will disclose data breaches to you. You may hear about the need for certain organizations to register with the Data Protection Commissioner. I refer to the Data Protection Commissioner as the DPC on these slides. It's required for certain types of data controllers, large banks, financial institutions, but not required for radio stations. Legislation. Looking at the legislation, I've outlined already that we have the Data Protection Acts 1988 and 2003. The General Data Protection Regulation will take effect right across the EU on the 25th of May. There is a new data protection bill going through the legislative process at the moment, which fills out some of the details. There are some areas of the data protection regulation where individual countries have a degree of discretion about how they implement aspects of the regulation. And our data protection bill, it's not going to be law by the 25th of February, but hopefully it will be law this year. Dataprotection.ie is the Data Protection Commissioner's website, which provides excellent information for organisations, for data subjects, and about the law. Examples of personal data. Just to give you an idea of where you as radio stations are picking up personal data, listener, viewer text, emails, direct messages, call sheets are more in the television area, employee files, those of you who are dealing with employee contracts and payroll, and accounts are dealing with employee files, marketing and advertising contact lists, and accounts information about the people you're doing business with on the advertising side. A sound recording is personal information about an individual, CCTV images, email addresses, records of websites visited. If your website uses persistent cookies, those of you involved in the IT side of your business will know that you're obliged to notify individuals about the information, including the fact that you use cookies. It's a piece of software that tracks what is put on your laptop when you visit a website that tracks where you go online. Employee files, personal details for booking courses, payments for DVDs or whatever you might be selling on your website. That not a lot of you will be selling material on your website, but all of this is personal data and you need to think about it. As we'll see, there are exemptions that allow you to process it for news and current affairs purposes, for the legitimate purposes of your business, but you still need to be aware that what personal data, what personal information you hold, so that you consider how you need to treat it under data protection legislation. 8 rules of data protection. Under existing data protection legislation, there are 8 fundamental rules. These have been narrowed down, or not narrowed down, actually more expanded and consolidated into 6 guiding principles under the GDPR. But personally, I've found that if you understand the 8 baseline rules that have always existed, it's much easier to understand the new 6 guiding principles, which are expressed in wider terms than the 8 rules. So we're going to have a look at these 8 rules because they have not been done away with. They've just been consolidated and restated. So they're baseline rules. They applied before and will continue to apply after the GDPR, but in modified and expanded form. If you understand these baseline rules, you know and understand the fundamentals of data protection law. 8 rules of data protection. These are the 8 rules. There must be fairness in how you obtain and process data. Data must be collected and processed for specific and lawful purposes only. 3, it must be disclosed for those specified purposes only. 4, it must be kept safe. 5, it must be kept accurate, complete, and up to date. 6, the amount of information collected about data subjects must be relevant and not excessive. This is now under the GDPR become known as the principle of data minimization, about how much data you keep about people, how much data you request and how much you keep. 7, retain it no longer than is necessary for the specified purposes. And we'll be looking at this in some detail shortly. This is the rights of rectification and erasure are very important under the GDPR. And 8, to provide a copy to the data subject on request. And there is a data access right under the GDPR that's still there. If somebody asks you for information that you hold about them, you are obliged to provide it within 30 days, and you must provide it in a form, under the GDPR, you must provide it in a form that they can read and transfer to somebody else. Now we look at the next slide is 6 main data protection principles. Article 5 of the GDPR summarizes those and consolidates those 8 rules by saying data processing must be lawful, fair, and transparent. There must be purpose limitation in the data collected and processed, i.e. it must be used for specified purposes. The principle of data minimization must be applied. Only collect what data you need and only keep what data you need. 4, the processing must keep the information you process accurate and up to date. We look at that. There is an exemption for news and current affairs. 5, there must be a limitation on your storage of identifiable data, so you keep it for no longer than is necessary for the purposes for which it was collected, and you must keep the data confidential and secure. An overarching principle on the data under the GDPR is that of accountability, and this is what's really important and why stations are being encouraged to put in place a data protection policy, to be able to show the steps your organisation has taken to comply with the GDPR. Fairness in obtaining. Now we're going to look at in detail what the original 8 principles, now the 8 rules, now the 6 guiding principles mean in practice. In terms of being fair in obtaining the data, does the individual data subject clearly understand that data is being collected about them, what data is being collected, and why it's being collected? You give a shout out for a competition, you need to make clear what data you're collecting about them, why you're collecting it, and the fact that you will be collecting it. But that happens automatically when we say text in with your name and your contact number, or text in, their contact number comes up automatically, or your email, but text in with your name for a chance to win, whatever it is. They understand what data is being provided by them and why it's being used, and that's the only purpose for which you can use it, i.e. that competition. Specific and lawful purposes. You need to be clear about what exactly you're going to do with the data. Is the use you're going to put it to lawful? And does the data subject know what that use is? The data collected must not be excessive by reference to that stated purpose. This is the data minimization principle. You must only hold the minimal data required for that specific purpose and no more. It may be interesting to know how many people who enter a competition are married or not married, or are suffering from a particular health problem or not suffering from that particular health problem. But that is information that you don't need for the purposes of entering the competition. So you don't need to ask them, and don't ask them anything else. You aren't entitled to ask them for any more information other than the minimum amount you require for the purposes of running the competition or whatever else the specific purpose is. Disclosure for specified purposes only. It's important when you collect data that you use it and disclose it, share it with other people, only for the specific purposes for which the data was collected. And indeed, you shouldn't be sharing it with anybody else unless the data subject has agreed to that. Now, there might be situations where in the normal course of your business, it's reasonable to expect that you would share that information. But in a sales and marketing context, I've mentioned this already, make sure that you're familiar with the direct marketing regulations if you're making cold calls. And if you are providing information, for example, employee contracts, if there is a requirement in employee contracts that an employee needs to go to a medical examiner if they've been out sick for a particular period of time, there should be a clause in the contract that says on the medical examiner, you consent to the medical examiner disclosing your information back to us if we need it, because that's health information. That might be something that would be regarded as being in the normal course of your business, but it is recommended that you get specific consent for the disclosure of the information by the medic to your organization if you need it. That's just an example. I don't want to make a big deal about it. That's just an example of a specific consent being given for data that a third party has been given to you, or you giving data that you have to a third party. 4, safekeeping. This is a fundamental aspect of data protection law, keeping data safe. And this is what radio stations need to do now. They need to audit their security and safekeeping systems for personal data held. For example, cloud storage. Are you satisfied that your cloud storage provider complies with GDPR? Do you have a contract in place? Usually you sign up to terms and conditions. You need to check those terms and conditions to make sure that Google or whatever cloud storage system you're using complies with GDPR. Google have gone to extensive lengths to ensure that they comply with GDPR. They are based in the US and they avail of something called the US EU Privacy Shield, whereby companies will self-certify saying, we confirm that we are compliant with GDPR. The very baseline things like, are your premises locked? Are your storage facilities locked? You need to think about your own organization. For example, where are employee files, which can contain sensitive personal information, which contain lots of personal information about each of us as individuals? Where are they kept? Who has access to them? Are accounts computers set to time out after a particular period of time if somebody isn't using the laptop or the PC involved? Are cupboards with filing cabinets with employee data in them, are they kept locked? Who has access to them? If the information is kept on your in-house server, are the relevant files password protected so that only those who need to see that information can see it, or can everybody in the organization see private employee data? Similarly, sales and marketing information. It may be that newsroom people need to see certain elements of the sales and marketing information, but it's unlikely that they need to have access to all of it. So you need to think about internally, are we protecting our information so that it's only available to certain individuals on a need to know basis? Are we minimizing the number of eyes that are going to see that information? Because this is all part of the safekeeping. IT protection. What IT protection measures have we put in place? The more sensitive the data and the greater the amount of data that's held, the greater the level of protection that you need to apply. But it's a matter for IT departments to decide what they think is appropriate levels of protection. If an employee is leaving, are you changing their passwords? You want to keep the data safe, for example, whether it's access to Facebook, more access to the company servers. If you made sure that the passwords are changed so that they don't have access to the company servers once they leave the organization. These are all things that you need to think about and be able to show that you've thought about in order to show that you've done a risk analysis and you've taken what measures you can to comply with GDPR. Keeping data accurate, complete, and up to date. This is usually going to be relevant particularly in employee files. Make sure that they're kept up to date. If there's a note that somebody's out sick, but then they come back to work, or after a long period of time, make sure that it's clear that they have come back to work if there's an allegation of misbehavior or breach disciplinary policy, but it's found that somebody was innocent of what they were alleged to have done, that the outcome of that is kept up to date. Now, this has been raised in the context of archived news stories. There is an exemption from data processing, data protection legislation for journalism and freedom of expression. Now, it's quite widely drawn and we don't know exactly the parameters of it. But I have come across a situation where a station was telephoned by somebody who wanted a story about them taken down and said, I have a right of erasure. And my advice to the station was, you're entitled to leave it up there. When you weigh it up against the rights, legitimate rights and expectations and entitlements of this individual, in this case, the individual was a tax defaulter, had settled with the revenue and wanted the story taken down. But it was publicly available information published on the revenue website, and it was a fact that he had been a tax defaulter and had settled with the revenue. And that was part of the station's news archive. He couldn't just demand to have it taken down. There might be other situations where you decide, in light of the sensitivities of the case, in light of the legitimate expectations of the data subject, that you may take it down. But each case needs to be assessed on a case-by-case basis, but you don't have to go back constantly updating your old archive news stories. Don't worry about that. The GDPR gives rectification and erasure rights to data subjects. Erasure right is subject to the countervailing lawful entitlement of the data controller to retain the data in the circumstances, for example, that I just outlined about a news service. Data held is relevant and not excessive, stroke data minimization. What you need to do when you are collecting data is think in terms of how little data do we need to collect. I'm noticing already that some organizations and advertising agencies and like are saying, because of GDPR, they don't want to have anything to do with data. They don't want people's names and addresses because it just adds an extra level of responsibility to have to look after that information and protect it under data protection law. So I think we're going to see a gradual slide off in sort of the hunger for data. People are going to be much more careful about how much data they collect. The idea is to minimize the amount of personal data you hold about individuals. There may be situations where you decide, okay, we're going to hold on to that data, but we're going to hold on to it in anonymized. We don't need to hold on to those names for historical or archival purposes. We just need the information or the statistics, and we don't need the details of the information. So that if you're holding on to data for a long time, you might want to think about anonymization. 7, retention and erasure. How long do you need to keep the data by reference to the specific purpose for which it was collected? There may be different, you need to be able to show that you've considered each category of data that you hold in the station. For example, sales and marketing, employee data, and listener data. How long do we need to keep that? Maybe you'll say for 3 or 4 years after an employee leaves. Maybe you'll say for 2 years after you last did business with a particular advertiser. Maybe you'll say indefinitely, because when it comes to information about listeners, because they may have, recordings, you may keep that for, let's say, 2 years or maybe 3 years in case there's a defamation claim arises out of it. Or somebody in a newsroom said, well, I have contributor lists for expert contributors that I carry around with me all the time. That's fine. One, the journalism exemption would possibly apply. But 2, there's a legitimate reason to hold on to it indefinitely. But at least you need to be able to show that you've thought about how long should we keep this data, and have erasure policies in place to get rid of it as soon as possible if you don't need it anymore. So there may be different retentions periods, there are erasure timeframes for different categories of data. But what you need to consider is, okay, if we're facing legal claims, how long do we keep this data? If there are going to be regulatory complaints, how long do we need to keep this data? If we're going to have employee claims after termination of employment, how long do we need to keep this data? You need to think about each category of data that you have and think about what would be the appropriate retention or erasure policy in respect, erasure policy in respect of that data. Provide copy on request to subject. This was under the old rules in the GDPR. provides a similar right of access for the data subject to a copy of all personal information held about them by an organization. In addition, they're entitled to information about what's being done with that data, including when they're given the data, they should be told what your retention and what your rectification and information policies are, and who to contact if they want to rectify or ask to have the information erased. The information about what you do with it and who to contact about what your erasure and retention policies are should be provided along with the information when you provide the information following a request. And there's also what's called the principle of data portability. The data must be available to the data subject in a format they can read and make available to a third party if they wish to. It is important to respond to these requests within 30 days, and you've got to know where the data is. Now, something that's relevant here is if you have files going back over 20 years because nobody has ever culled them or done a bit of housekeeping and cleaned them out, if anybody asks for personal information about them, you must go back through all of those files for 20 years. If, however, you have a policy and say to, for example, a former employee, no, we get rid of all our data about former employees after 6 years, then you don't have to go back any further than 6 years because you know all of that data is simply not available that's older than 6 years. So you're actually making life easier for yourselves to do some serious housekeeping now so that anything that needs to be erased is erased, and you can start from now on and treat your data in accordance with your retention and erasure policies in future, so that if somebody makes a request, you know you only need to go back 6 years because anything before that will have been erased, for example. So it's helping yourselves if you do some serious housekeeping now with old data that you may not need to keep anymore, because if somebody makes a request, you'll be obliged to go into that cupboard and look through every piece of paper to see what you have about them. Also be aware that on emails, maybe emails dealing with somebody, and usually emails can be collected, but it's a major hassle. So just be careful about it. Security. We've gone through the 8 rules, and I want to focus on security for a moment. We've mentioned this, but really this is the key to perhaps the most important element of data protection, I think, because if you don't keep data secure, you are going to be liable if the data becomes lost or inadvertently disclosed or under threat of being disclosed to somebody who isn't authorized to see it. Then there are certain reporting mechanisms kick in, both to the Data Protection Commissioner and to the individual whose data has been lost or disclosed in an unauthorized manner. So security is really, really important. You need to think about, analyze, and risk assess the physical security of your business surroundings. When is the building locked? Is it alarmed or not in use? Where are computers located? Can members of the public look at your computer screens? What do you do with printouts? What do you do with notes that might be scribbled on bits of paper? Have a shredder or a shredding service and shred those scraps of paper. You often hear horror stories about medical records being dumped in backyards or on dumps. Well, actually, mercifully, not too often, and less these days. But you don't want somebody to be going through the bins or for a black sack to fall off a bin lorry and find all of this personal information about individuals that you've written down on scraps of paper blowing in the wind across the road. And it may sound sort of facetious, but it's not meant to be, because this is how data gets lost. If there's one thing you can do to keep data safe in your organization, it's get a shredder, and anything you don't need, shred it. And make sure that you leave as few bits of paper with personal data on it lying around as you can. I know that's working in the sector. We're always scribbling down numbers and names and messages and information. Even if it's for journalistic purposes, which as we'll see in a minute, there's an exemption does apply, you're still obliged to keep that data safe. BYOD means bring your own device. A lot of us will be bringing our own phones and laptops to work, and we prefer to use the devices that we're comfortable with, that we're familiar with, how they work. However, every company should have, and every station should have its own BYOD policy. Laptops should be encrypted. Encryption is perhaps the most important thing you can do. If somebody leaves their laptop in the back of the car, in a pub on a Saturday night, this can happen to any of us, or if it gets lost or stolen from their apartment or their house, you will be able to sleep easy if you know it's encrypted because it can't be accessed. So my advice is to make sure that all laptops and portable devices that can be encrypted are encrypted. That can apply to USB keys as well. In respect of phones, have a look at the IT potential here. At the very, very least, have phones password protected at all times, that everybody is expected to keep their phones password protected, and investigate what the remote wipe capacity will be. Can you ring up Vodafone and get them to wipe all the data off? Do you have a remote wipe facility on your phone? Something that will mean that if you lose the phone, you can get rid of any company data on that phone straight away that might be personal data about individuals. Make sure that all staff are aware about the importance of security policy. And they understand about need to note only sharing of passwords, e.g. to social media accounts, onto the well, that's part of your social media policy anyway. But for the website, most particularly the company server, make sure that only those who need to be able to access it are able to access it, or who need to be able to access certain areas of it are able to access it. If there's a breach of any of these data protection protocols, you need to be really clear, everybody needs to be really clear in your station about who do I report it to? Who's going to be responsible for data compliance and data handling data breaches if one happens in our organization? Accountability. As I mentioned earlier, the requirement to demonstrate compliance runs through the very core of GDPR. Data controllers, such as radio stations, must be able to demonstrate that consent was given for any data that they collect, that appropriate technological and organizational measures are in place to ensure that the processing is conducted in compliance with the GDPR. That involves having a data protection policy in place and training and staff awareness, and that there are compelling legitimate grounds for processing the data when the data subject objects to such processing. So, for instance, I gave you the example earlier on about the individual who wanted data about him taken down, and he said that he had an erasure right, but there was a countervailing legitimate right of the company. There were compelling reasons for the company to keep that story up on its news archive, on its website. So that was a countervailing, compelling legitimate ground to continue to have that story up there, even though the data subject objected to that processing, i.e. having the information up there. Demonstrating compliance. Stations can demonstrate compliance with the GDPR by 1, implementing a data protection policy, 2, ensuring that they have an up-to-date privacy statement on their website, which is required if you have what are called persistent cookies on your website. That's a question for your IT department. And B, if you collect any information on your website about individuals. Some stations will, some stations won't, most stations won't. And also adhering to any approved codes of conduct or approved certification mechanisms. These will gradually become available on the Data Protection Commissioner's website after the 25th of May, and to ensure that you keep records of your data protection protocols, your data protection policy, which will be the same document, evidence of what training and awareness programs you have for your staff, evidence of if there was any breach, how it was handled. Keep records of everything. Data protection policy. A data protection policy is, well, how I would explain it. It's an in-house document that details what data you hold, how it's collected, why it's collected, how it's held secure, how it's kept up to date, what your erasure policy is, what your response to disclosure requests is. They're currently known as Section 4 disclosure requests, but they'll just be known as data access requests after GDPR, and what training and education measures you need to be you implement. But you need to be able to show how your organization has considered, recorded, and implemented all of the above. Now, what Learning Waves is doing at the moment, it's together with our own company, Media Lawyer, we're devising a template data protection policy. We have already supplied, and these are available from Teresa Hanratty and Learning Waves, we've already supplied these slides, a checklist that you can go through to identify the different categories, in respect of each different category of data that you hold in your organization, each different category of personal data. You can go through and check, what do we do? Why do we hold it? what information do we hold, how did we get consent, so that what you need to do is effectively do a data audit at this stage. And when you have that information, you can then insert that information into the policy the template data protection policy that we will be supplying in the next week to stations through Learning Waves. It's really, really important that you do this. If you have a data protection policy, you will be in a position to demonstrate in the event of a complaint or a data protection commissioner audit, you'll be able to demonstrate what measures you've taken to comply. Website privacy statement. I've mentioned website privacy statements. They're required if you collect personal information via website feedback forms, donation forms, if you use persistent cookies, excuse me. If you collect data in a way that the user won't know, e.g. tracking IP addresses or email addresses or Google Analytics. And there is guidance on this from the Data Protection Commissioner's website. Exceptions from data protection law. It's a station relevant, not exhaustive list. This is really, really important for stations to understand. I've been mentioning it as we go through that there are certain exceptions. If the data is held and processed for personal, family, or household affairs or for recreational purposes, data protection law doesn't apply. If the data is disclosed for the purposes of prevention of injury or damage to the health of the subject, or prevention of serious loss or damage to the property of the subject, or the protection of the subject's vital interests, then data protection may not apply. Now, this happens often if you have a situation where the Gardaí put out a call for somebody who's gone missing. The Gardaí, in collaboration with the family, have decided that the protection of prevention of injury or damage to the health of the subject or their vital interests requires that their photograph, their name, the fact they've gone missing, be published. But this is a process that Gardaí would go through in collaboration with the family. It's one that I wouldn't recommend that you take on yourselves unless you have compelling information whereby you as the radio station are absolutely satisfied that this is necessary to protect the injury, the vital interests of the data subject. For the administration of justice, data may be disclosed for the purposes, for example, of a criminal investigation. Now, this is important. Where the processing is in furtherance of the legitimate business interests of the data controller for the purposes of their business, unless it's unwarranted by reference to the fundamental rights, freedoms, and legitimate interests of the data subject, it is recognized that you will need to process certain data, for example, maybe outsourcing your payroll, something like that, for the purposes of running your business. And so long as it doesn't have a disproportionately adverse effect on the fundamental rights and freedoms of the data subject, that is fine, and it can be exempted, it can be regarded as exempted from data protection law, but you still must keep that information safe. There's also a freedom of expression exemption, which I've given an entire slide to. Next slide, freedom of expression exemption. At the moment, there is an exemption for where data is processed for journalistic purposes with a view to publication. This terminology has been changed, and it's broader under the Article 85 of the GDPR. And the current data protection bill, this is an area where Ireland has some discretion about how it implements it, reads: the processing of personal data for the purpose of exercising the right to freedom of expression and information, including processing for journalistic purposes, should be exempt from compliance with provision of the data protection regulation, where, having regard to the importance of the right of freedom of expression and information in a democratic society, compliance with the provision would be incompatible with such purposes. Now, that is quite a how long is a piece of string exemption, but it is significant that the GDPR recognizes that exercising the right to freedom of expression and handling personal data for journalistic purposes it would be inconsistent with, if you had to apply data protection legislation, you couldn't function effectively, and this would be damaging to society. So they do recognize an exemption. We don't know the full parameters of this. There may need to be high court cases to determine this in the future, but that important exemption does exist. However, the information must always be kept secure. If a breach happens, the current position: if a breach happens, there's a security breach code of practice. If you lose data, if it gets stolen, if you're hacked, if a laptop is stolen with information on it about individuals, there is an existing code of practice which will be updated after the 25th of May. data breaches under GDPR. The bottom line is that under the GDPR, there are two types of notification you need to think about. If we have lost control of data, if we've lost the data, if it's at risk of an unauthorized disclosure to a third party, do we need to notify the Data Protection Commissioner? And do we need to notify the data subject affected? Do we need to notify the Data Protection Commissioner? The answer is yes, and within 72 hours of the breach, unless the breach is unlikely to result in risks to the rights and freedoms of data subjects. If you have encrypted all your laptops, the breach is unlikely to result in risk to the rights and freedoms of data subjects, and you don't have to notify. Do we need to notify the data subject? Yes, if the breach is likely to result in high risk to the rights and freedoms of the data subjects. So you actually need to investigate the level of risk, and is it likely to result in high risk to the rights and freedoms of the data subjects? If so, you've got to notify the data subject as well. If your laptop is encrypted, if you can remote wipe your phone, you don't need to worry about that. So that's really, really important, that encryption message that I was giving earlier on. No notification to either will be required if the data lost or stolen is in a form that's encrypted. You need to keep records of information about all breaches and the decisions made and the actions taken, as you may need to produce these to the Data Protection Commissioner if there's any kind of complaint or investigation arising out of a report. Check www.dataprotection.ie after the 25th of May for further updated advice about this. Policing data protection. The Data Protection Commissioner has various powers in relation to complaints and investigations. There are different approaches outlined under data protection law. She can issue information notices, enforcement notices, prohibition notices. I'm not going to go into those in detail because they don't really affect you unless you have a problem, except in relation to complaints and investigations, in that you do need to have all those records to show that you've done everything you can to try and protect that information. Breaches of data protection law under GDPR, things get more serious. They get more serious because the Data Protection Commissioner now has the power to fine data controllers and processors for breach of the GDPR. This is something, it is a new development, and it's really, really important. Now, I would speculate that if organizations like radio stations can show that they have made reasonable efforts to try their best to comply with data protection law, then I think they're unlikely to be subjected to a fine, certainly not in the first couple of breaches, if and when they happen. However, if an organization loses information or a data breach is reported by a data subject to the Data Protection Commissioner, the Data Protection Commissioner goes to the radio station or whatever business it is that has been responsible for the breach, and they say, oh, data protection, we're going to get around to that. That's when I'd say they are in danger of being fined and the Data Protection Commissioner coming down heavily on them. Everybody should know about this and be able to demonstrate they've taken steps and done the best they can to comply with GDPR. There are also, under the GDPR, enhanced rights for data subjects to sue data controllers or processors under civil law for damages for breach of data protection law. Increasingly, you'll find that insurance companies are offering special data protection special data protection insurance, and though CEOs looking at this might like to have a look at that to see if they need to take out special insurance to cover the company's liability in the event of a breach of GDPR. At this point, what stations need to do is to first nominate somebody who's going to be the data protection coordinator in the organization. You will hear talk of companies needing to appoint data protection officers. Under the GDPR, the formal appointment of a data protection officer is only required in certain very large organizations and public institutions processing large amounts of personal data. However, it's good practice to have one person in your organization nominated as the principal data protection coordinator, compliance coordinator in your organization. The next thing you need to do, and you need to start this now, is to carry out a data audit and risk assessment to see what data you hold, have you got consent to hold it, do you need to do some housekeeping and get rid of it, what security measures do you have in place. 4, identify any security risks in your data collecting and processing. 5, devise and implement a data protection policy that addresses those risks and shows how you're going to obtain consent, keep the data secure, minimal, what your erasure and retention policies are, what your rectification policies are, what is your data subject disclosure protocol. Also, if you are transferring data to third parties to process that data, to carry out any function for you that requires you to disclose personal data to those third-party contractors or companies, do you have contracts in place that ensure that those third-party companies will process the data in accordance with data protection legislation, stroke the GDPR? You need to have an action plan for when a data breach occurs. You need to train staff. Taking part in courses like this is part of that process. You need to be able to demonstrate compliance with the GDPR, and above all, buy a shredder. That's a baseline. Get rid of as much personal data that you hold on paper that you can. If you don't need it for the future, if you haven't got a demonstrable reason for holding onto it, shove it in the shredder and get rid of it. Be aware of data protection law. Start compliance work now. Be able to demonstrate your awareness and commitment to getting to the point of maximum compliance with the GDPR. I hope that slide presentation has been helpful to you. Thank you.